Today I want to talk about reckless driving in this crazy congested Northern Virginia area. As we all know, if you live here or if you're just visiting and you drive or you're a passenger in a car that's out on the roads in Virginia, it gets pretty crazy out there. Most of the speed limits on the main highways are 55. There's a few areas where it's 60 in Northern Virginia. If you get outside the Northern Virginia areas, there's some that are up to 65 and 70. But for the most part, especially here in Fairfax County, most of our main highways are 55. In a lot of the residential areas, it's 25 miles an hour. Sometimes it's even a smaller speed than that. And then out on some of the other roads, you have like 35 and 45 mile per hour areas as well. When we talk about reckless driving, the reason I started with the speeds is because reckless driving has a lot of different ways that you can be charged. One is speeding, and in Virginia, if you're just going a few miles over the limit, it's going to be just a speeding ticket, which is a traffic infraction. You can prepay that usually. You'll get points assigned from the DMV, not from the court, but you don't actually have to go to court. It's actually something you can pay online or call the court or show up to court and make a payment on. However, if you're going 20 miles or more over whatever the speed limit was, or if you're going 85 miles or higher, regardless of what the speed limit is in Virginia, that is considered reckless driving. That means it's not just a traffic ticket anymore. It actually is a criminal offense. It's a class 1 misdemeanor. It carries the same penalties as a shoplifting charge, as a DUI offense, as an assault and battery. It's up to 12 months in jail. And it's up to a fine of $2,500. And then you can also lose your license for up to 6 months. Now, those are extreme penalties, and most judges and courts are not going to give you jail or take your license or even give you the high $2,500 fine. To get those things, your record has to be really, really bad. There has to be some other kind of aggravating factors, like somebody was hurt or killed in an accident, or you have to be going really high speeds. A general rule of thumb usually in different courts is if you were going 90 miles or higher, you start getting into an area where judges are really looking to take your driver's license, or they're looking to start putting people in jail. And that could be just for a day or two. Sometimes it gets even more. As you get into the hundreds, you're increasing the chance of you going to jail even more, and you're increasing your fines, and you're increasing the chance that you're going to have your license suspended. And whether or not you can get a restricted privilege to drive for work, school, childcare needs, medical appointments, things of that nature, is going to be up to the judge that hears your case. So when we're talking reckless driving, we're talking about a permanent criminal charge. We're talking about something that could possibly have immigration consequences for somebody that is not a U.S. citizen. We're talking about people that have to answer for this kind of an offense on a background check or on a clearance or on a polygraph or some of those things. There's a lot of government agencies and military bases in this Northern Virginia area, and oftentimes those are things that may end up coming up in your background checks, or they're things that you're required to report to your supervisors. Sometimes people can get fired from a job not because they got the charge, but because their job found out about it and it wasn't reported to them. It's the not reporting part that can get people in trouble a lot of times. Okay. So when we're talking reckless driving, you got to keep those speeds down, because if you're going over 20 or if you're going 85 or higher, regardless of whatever the limit is, you're starting to face some of those penalties, and you don't want to wind up having to lose your license or pay high fines or even go to jail, right? Also, you have to come to court on those. So when you get your ticket, and it's just a traffic offense like speeding or running a red light or not having a seatbelt on, or your tags are expired, things like that, a lot of times the ticket will be crossed out and say you can avoid coming to court if this is crossed out. The officer doesn't cross that out on a reckless driving ticket because you're required to come to court, because it is a criminal offense. Now, there are certain jurisdictions that will allow you to avoid coming to court in certain circumstances. For instance, in Fairfax County, where my law firm is, there's not a set rule or anything like that for this, but the judges, there is a policy in place basically that the judges will usually follow, that on a first time appearance on one of these cases, if it's under 90 miles an hour, we can have a signed authorization from you and go and appear for you in court without you there. If it can't be resolved on that court date, the judges expect that you're going to be in court the next time. If it's over 90 miles an hour, that's not something I'd feel comfortable having you sign, because I know the judges are not going to like having me there without my client there on something that's that high of a speed. If you live out of state, if you're military, things of that nature, if you live out of the country, sometimes we can file a motion ahead of time before your court date if it's a higher speed and say, hey, Your Honor, this person lives so-and-so, or this person's deploying to the military and has to leave on such a said date. Would you please waive their appearance for the court date so that I can come and handle it for them without you having to be there? If the judge authorizes that, then that's okay. But if we don't have a judge's authorization, the highest speed that we would feel comfortable going to court for is anything under 90 miles an hour. Okay. And even then, it's not a given that we can resolve the case without you. It may be that it has to get continued and then you have to still come to court with us the next time around. So just understand that reckless driving is a whole other ballgame from just getting a traffic ticket. Now, we talked mainly about speeding, but there's other types of reckless driving that you can get to. The next most common one is going to be involving accidents. If you are involved in a car accident out on the road and it's not something that's just minor or simple, a lot of times an officer will charge you with reckless driving general. And what that means is that the officer felt that something about your case, whether it's speeding, whether it's weaving lanes, whether it's driving too fast with the roads being wet, whether it's cutting people off, taking a ramp too quickly, whatever it is that the officer is alleging that you were doing, or that the witnesses say that you were doing, or maybe even that you admitted to the officer that you were doing, they're going to charge it as reckless driving. When you come to court, there is a chance that a judge or sometimes a prosecutor could reduce that charge from reckless driving down to improper driving, which is just a traffic offense, so that you're not facing the criminal charge. But either you have to have a trial where a judge deems that that's the level of bad driving that you had in order to reduce that charge down for you, or the officer could tell the judge that they think it's something that really is warranted to wind up as an improper driving conviction as opposed to reckless driving. Or sometimes there's a prosecutor involved where you or your attorney would be able to speak to the prosecutor. That's different in every county. There are some counties where you get to talk to the prosecutor on these type of offenses, and there are often, or many counties such as Fairfax, where you don't get to talk to a prosecutor. And if you go to court on your own, it's just you going in front of the judge with the officer. Now, if you have an attorney, your attorney will always try to speak to the officer. And if there is a prosecutor involved, your attorney will always get to speak to the prosecutor that's handling the case and see if we can come up with some kind of resolution of your case before we go into the courtroom. If we're able to do that, there's usually a form that we fill out, or we have an agreement and can go in and represent that to the judge. Again, that depends on the county. Most counties have a form now that we would fill out with the prosecutor. Everyone would sign it and we would take it in before the judge. Most judges will honor what's on those agreements. Sometimes a judge is not comfortable with whatever the agreement is. For instance, if it's a really high speed and it's not calling for a loss of license or jail or something like that, there are judges that will say, I'm not going to take this without a loss of license or without jail time or without a higher fine, or you know what, at this speed, I'm not going to give you a reckless driving charge, or I'm sorry, at this speed, I'm not going to give you a restricted license to drive because I don't like how fast you were going. So sometimes a judge could reject that agreement, and then we either, have to go back and talk to the prosecutor and figure out something that the judge would probably accept. Or sometimes it gets continued, or even sometimes there could be a trial. So with reckless driving, there's a lot of different options, and you want to make sure before you're going to court. So once you get that ticket from the officer, one of the first things you should do is just call an attorney. I'm a criminal and traffic attorney. I offer free phone consults. I can do it over video. I don't generally do in-person consults for these type of cases because it's pretty easy for me to explain how to handle these kinds of cases. And so to maximize my time and your time, I usually do these over the phone, sometimes over video. And what I'll do is kind of walk you through the process for whatever that county is that you're charged in, walk you through the penalties, how it's going to work, what it's like if you go to court on your own, what it's like if you go with an attorney, and then you can ask me any other questions that you may have. It's really good to at least talk to an attorney so you know what to expect, so that you're not surprised when you go to court as to how things are playing out. Or if there's something that you're concerned about, the attorney can usually address that for you so that you can have the attorney help you out to try to figure out how to avoid or to minimize whatever it is that you're most concerned about. For some people, that's the criminal conviction. For others, that's the driving without their license. For some, it's the jail time, and for others, they need to keep their fines and court costs down. They're trying to minimize insurance. because when you get more serious charges like reckless driving as opposed to just a traffic ticket, your insurance company can end up upping your rates. Sometimes they drop your rates. There's a lot of things that can happen with that the court has nothing to do with, that your attorney doesn't really have anything to do with, but that you may have to end up dealing with either from a DMV, the Department of Motor Vehicle perspective, or from an insurance perspective once they get their hands on it. Speaking of DMV, or the Department of Motor Vehicles, in Virginia, that's what they're called. In some other states, they're called the Motor Vehicle Association. They are the ones in Virginia that assign points. So oftentimes I'm in court and I'll be waiting for my case to be called for my client, and I will hear people say, hey, Your Honor, I just don't want the points on this case. And the judge will tell you they don't have anything to do with the points. Now, the judges could reduce the case so it minimizes your points or eliminates points, and some judges will do that, but they don't have to, and it's not up to them to tell you or inform you about what points you're looking at in terms of your charge. That is up to the Department of Motor Vehicles. So if you're convicted of an offense or you prepay a ticket in Virginia, the court will send that information over to the Department of Motor Vehicles, and when the Department of Motor Vehicles in Virginia gets it, they're going to assign whatever points there are for your case. In Virginia, you start out at a zero balance when you first get your driver's license. And every year that you don't have a moving violation, you get 1 positive point. The best record that you can have in Virginia is a +5. And what that means is that you've had 5 good years of driving with no issues on your record. And every year you did that, you got the 1 point. If you get any violations, let's say a 3-point violation and you were a +5, you're going to go down to a +2. Or let's say you were at a +2 and you got a 4-point violation, you're going to go down into the negative at a -2. So the only way that those points fall off is every 2 years the points will come off. And then after 3, 5, or 11 years, typically that's the amount of time, then the charges will come off. So for instance, on a reckless driving charge, that's a 6-point violation. So if you were a +5 and you got convicted of reckless driving, you're going to go down to a -1 on your record. That charge is going to stay on your driving record for 11 years because that's how long DMV will keep that type of offense on your record. And then the points for the -1 would fall off after 2 years. If you had good driving over those next 2 years, you're not going to get a positive point for the year you got the reckless driving ticket, but you'll get a positive point the next year that you stay out of trouble, and then you might be up to a +1 again. So remember that the points drop off for any offense that you have after 2 years, and the charges themselves will come off, whether it's a speeding ticket, running a stop sign, whatever it is going to come off after 3, 5, or 11 years typically. In terms of if you wanted to take a driving improvement course or something like that, there are some jurisdictions in Virginia when you get a traffic ticket that if you take the driving school ahead of time and you take it to court and show them that you've done it, sometimes they'll dismiss the case as complied with law, or they'll dismiss it and make you pay the court costs, or sometimes it's enough that they'll amend your case down to something else, either for lesser points or from a criminal charge to a traffic infraction, or sometimes they'll take it from a moving violation to something that doesn't carry points so that it helps you out on your record. In other courts, they don't do driving school for dismissal or things like that, and you're not going to be able to utilize that as much. However, most judges will at least consider the steps that you took to balance out the fact that you got a ticket. So even if it's not a jurisdiction here in Northern Virginia that will let you do driving school for dismissal, many judges will at least say, okay, you got this ticket and here's your record, and okay, you took a driving school, I'll factor that into what I'm going to decide to do in your case. And so that's something that can be helpful, whereas maybe you were going to end up with a reckless driving because you took the driving school, maybe you only get a traffic ticket then, or maybe you were going to get 6-point violation, but the judge decided to amend it down to a 4-point violation, which helps you out a bit. So even though they might not dismiss it like some counties do, it could help you in terms of your fine and in terms of it being criminal down to a traffic, and also in terms of your points. When it comes to reckless driving, the officers are out there, they're looking for you. I think we all can agree in this area, it's hard to drive in this area and not see either an officer that has someone stopped for speeding, or seeing somebody pulled over for speeding, or an officer responding to some kind of a car accident, or someone that's run a red light. And so or you might not have seen somebody pulled over, but you see an officer kind of hidden in an area just waiting around the corner or under the bridge or something like that to get people for speeding. And so you want to make sure that you're paying attention to your speed. One of the things I often hear people say when they go to court is they'll tell the judge, well, I wasn't going that fast. There's no way I was going that fast. And the question that I've heard judges ask a lot over my years of practice is, well, were you looking at your speedometer the whole time? And that's kind of a tricky question, because if you answer no, well, then guess what? You don't really know exactly what speed you were going, because even for like an instant, you could have been going that speed and then maybe you slowed down, or maybe you realized the officer was there, or maybe you didn't even know the officer was there, but you realized, oh, wait, I'm going too fast here. I better slow down a little bit. And so it might have been something that you caught on your own, not even knowing that the officer was right behind you or was sitting there waiting to catch you going that speed. And so the number one thing is you probably weren't looking at it, but if you tell the judge that you were looking at the speed, well, then I don't think most judges are going to believe you, because the reality is, even if you were looking at it the whole time, it's not reasonable that most people are staring at their speedometer the entire time they're driving. So maybe for you, that's something that you do, but I think it's going to be a hard sell for a judge. Now, in terms of fighting your speeds and things, we just talked about the one thing that people do, which is tell the judge, I wasn't going that fast, but you don't really have a way to show that. The officer has to test the equipment that he uses to clock your speed before and after his shift. So they've got to make sure that it's in working order. He's got to have the correct paperwork with them, and there can't be any issues with it. And so if it wasn't calibrated right, or if he forgot to do it, or if he doesn't have the correct paperwork when he comes to court, or there's any other issues that are involved in either the LiDAR, the radar, pacing, and any of those ways that the officer can clock your speed, those are things that your attorney can help you challenge. They're things that you can try to challenge. There's different ways that the speeds are calculated or clocked by the officer, and in order to challenge those, you have to be familiar with them. And so if you're not familiar with what type of device the officer used to clock your speed or how to challenge it, then it's hard for you to do that when you go to court. So at least talking to an experienced attorney can at least let you understand, okay, this is what I'm going to have to do in order to challenge this, or it's something you can research on your own. But if you're not able to understand those things, to be able to question the officer and confront him with that evidence, it's really hard to challenge that, because the judge is not just going to go off of the fact that you say you weren't speeding versus the officer says that you were speeding. The other thing is, nowadays in Northern Virginia, a lot of the officers have body camera footage or in-car camera footage on their cars, meaning so they're showing on their videos how fast you're going and that they're stopping you. And oftentimes it'll show on there like the speed they had to go to catch up to you in like a pace type situation and things of that nature. So sometimes they even have physical evidence of you actually speeding, which never helps your case, because then the judge actually gets to see how fast you were going and if any other cars were affected, versus just kind of envisioning it or hearing that maybe you were just going over the speed limit. Some of the things that I have my clients do to prepare for court, and when you call me on one of these cases, I'm going to tell you the same thing I tell everybody, is you need to get a copy of your driving record, whether it's a Virginia record or an out-of-state record. You should always get a copy of that so that you have it to go to court, or that you have it for your attorney. If you are a Virginia licensed driver, most of the officers are going to have your record when they go to court, because it's something they need to show the judge. Every once in a while, they'll forget it. So if you have a good record, you want to be able to show the judge that. So it's really important that you get that record. If you have an out-of-state record, the officers are not going to have that record. And so in order for you to be able to show, hey, I have a great record, I want you to do something better for me, you have to be able to show that record. So you need to request that as soon as possible. Some states take a little bit longer to get the records to you than others. Some you can access right away online. Some you have to put in certain requests for. And then with COVID right now, some jurisdictions are taking a little bit longer. So you want to do that as soon as possible. The other reason that you want to have that record is sometimes people forget. Sometimes people tell me, oh, I have a few things on my record, but then we get their record and it's a great record and there's nothing on there. And sometimes they say, oh, I have a perfect record. And then they get it to me and it's not so perfect. And I'm like, whoa, we got to do some things here. The reason that's important is to have you do different things depending on how great your record is, how bad it is, how fast you were going, or what the charges are. There's different things I'm going to have you do. The worse that the speed is, meaning the higher the speeds, the worse that your record is, the more things I'm going to have you do, like community service, like multiple driving classes, like writing an essay if you're a juvenile. I have my juveniles write essays on the dangers of speeding and what they're doing out on the roads, because they're so young and they're so new to driving. They need to help the judge understand that, hey, look, I get it, Your Honor, I messed up here and I'm learning, and I've now acknowledged what I've done wrong, and I'm going to figure out ways to make sure this never happens again. So that's really helpful for my juvenile clients. For adults, the community service and the driving schools are much more important. You can also get a copy of your declarations page of your insurance policy if it shows that you have a good driver discount. I've been able to show that to judges or prosecutors before and say, hey, insurance has taken a chance on this person. They've got a great record and a good history of driving, so let's give them another break, or let's give them a chance to show that they're not really a danger out on the roads because insurance is doing it for them. So that makes them a good risk to take, because insurance companies like to make money and they're not going to cut brakes for people that don't have very good records. Okay. The other things I have people get are anything involving, if you're in school, if you're involved in community activities, if you're working, if you have a clearance, if you need to be able to drive. Some people they use company vehicles, or they have to keep their license or to keep their driving record clear in order to be able to keep their jobs, or they have to do deliveries or drive to different locations or whatever they're doing for their jobs, and their license is very, very important. So things like that have been really helpful when I have a letter from an employer that says, hey, so-and-so needs to be able to drive for these reasons. He's a great employee. This is what he does. Then if nothing else, even if the judge is going to take your license, oftentimes they'll reissue a restricted license for those purposes, so you at least can be able to drive for work. And sometimes it can keep you from losing your license altogether, because the judge sees how important it is for you to have your license. So in order for me to be able to show the judge a little bit about you, I ask for all of those things, because all of that a judge and an officer and a prosecutor see is on the piece of paper. They'll say, okay, this person's charged with such and such, and they don't know anything else about you other than you're just one of the many people that they get that comes before them with this type of an offense. So I try to personalize you as much as I can to the judge, to put you in a better light with them, and show the positive things that you've been involved in before the ticket, and the things that you did to learn from this, like the driving schools and the community service, and the time that you spent trying to make amends for the bad choice that you made that day when you might have been going too fast. So I hope that this video has been helpful for you, and that you think about it the next time that you're getting out in the car. It's getting nice out. The officers are looking for you. They're going to be out more and more. And so watch your speeds, watch out for people walking around, for people on bikes, for kids running out into the roads, for people running. As the weather gets nicer, a lot more people are active. And then finally, one of the last things I want to talk about, even though this was mainly about reckless driving, is we have the new law that started in January. I'm starting to get a lot of calls on it. You can't hold your communications device. That's a cell phone, a tablet, computers, anything that's electronic like that. It's a handheld personal communications device. You can't even be holding it now while you're driving. So if an officer sees you doing that, they are going to charge you, and you're going to have to come to court. That is also an offense that you have to come to court for. They don't let you avoid coming. And so you're going to have to go and explain it to the judge. And each time you get that, it's going to be a fine, and the fine doubles the second time that you go. So just keep a reminder on that, especially as it's getting busier out there. You don't want to be messing around on your phone and then have something happen with a pedestrian or someone on a bike or a kid running into the street or anything like that. So just pay attention. If you ever have any questions, I'm happy to talk to you. Again, I hope this has been helpful. And just remember, keep your speeds down and be polite when the officer stops you, because the one thing I didn't talk to you about, which I meant to do, is be polite. It never helps your case when you're rude to the officer, or you're arguing, or any of those things, and then you come to court, and one of the questions that the judge asks the officer in trying to determine what to do in your case, or that a prosecutor will ask the officer what to do about your case, is, are they polite and cooperative with you? And if you're arguing, or if you're being mean, if you're calling them names, whatever it is that you're doing, those are things that are not going to look favorable on you. And sometimes when a judge or prosecutor might have been willing to do something better, they may not, or the officer may not want them to, because of how you treated the officer out on the side of the road. If an officer is being rude or something like that, let them do that. That's on them. You can always record it here in Virginia, say, hey, I'm going to record this. I'm not comfortable with this conversation, that sort of thing. And let them be able to show that like they weren't the one being professional or courteous or nice on there, but you don't want to be the one that's doing that, especially in this day and age when they do have body cam footage, because it's going to be something that they can show the court too, and you don't want to be on there not appearing your best self, because it doesn't help you to get a better result in your case. And then finally, I'm going to end this with don't admit what you were doing. So if an officer says, you know why I pulled you over, never say, oh yeah, I was speeding and doing those things. All it does is corroborate with the officer what you were doing. Don't say I was late for a meeting, or I was running to the airport and I'm going to be late for my flight. All those things are used against you to help corroborate that you were indeed going over the speed limit. So just remember to be quiet, be polite, be courteous, be respectful, hand over the information that the officer requests, like your license, your registration, insurance, anything like that that they may ask you for, and then just sign the ticket when they give it to you. And if there's any issues with why they gave it to you or proving it, you or your attorney, when you go to court, can fight that. But arguing with an officer on the side of the road is never going to get you what you want. So anyway, stay safe out there.